our IT assistant, who has been very kind and generous and provided staff and committee with Valentine's Day gifts. So thank you very much. Appreciate that. So we want everyone to be safe today, as always, and enjoy today as we celebrate Valentine's Day and look forward to the weekend. So with that, want to open the hearing on Senate Bill 222, prohibiting deference to a state agency's interpretation of a statute, rule, or regulation or documents by a state court or an officer hearing an administrative action. And with that, a brief from the reviser.
Thank you, Madam Chair. Senate Bill 222 would enact a new section of law that states when interpreting a state statute or a rule and regulation or some other document that has the force and effect of law, a state court or an administrative hearing officer may consider but shall not defer to a state agency's interpretation of that statute, rule and regulation, or document. They would be required to interpret the meaning and the effect of such statute, rule and regulation, or document de novo. After applying all customary tools of interpretation and rules of statutory construction pursuant to law, a state court or hearing officer shall exercise any remaining doubt in favor of a reasonable interpretation that limits the state agency's powers and maximizes individual liberty. And I can take any questions.
Thank you. Any questions? All right, then we will invite proponent conferee James Manley, State Policy Chief, Pacific Legal Foundation. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. My name is Jim Manley. I'm State Policy Chief for Pacific Legal Foundation. PLF is a national nonprofit law firm. We were founded 50 years ago by members of Governor Reagan's staff, and we litigate and pursue policy on protecting property rights, separation of powers, and equality and opportunity. Deference is a big issue for us. We've done a 50-state survey of the issue. It's an issue for us because we believe in separation of powers, and I think Justice DeWine on the Ohio Supreme Court captured it best. He said that deference allows the agency to assume legislative power as the rule drafter, the judicial power as the rule interpreter, and the executive power as the rule enforcer. And collapsing all the powers of government into one agency, sometimes one person, is the antithesis of separation of powers. And that separation of powers is the surest protection we have for individual rights. Even more important than our Bill of Rights is that structure of government that divides power. And deference collapses that. Fortunately, Kansas doesn't have deference. And so why are we here? We're here. The Supreme Court in Kansas about 10 years ago eliminated the concept of deference in this state, and that's been the law since then. If you look at our 50-state survey, though, most states on our map are yellow. It's unclear what state courts do there. Even if state Supreme Courts in those states have taken a stance against deference, there's inconsistency. And so what we want to do with the reason that SB 222 is a good bill is that it locks in the good law here in Kansas. And it makes clear what the deference doctrine is in this state, and it prevents backsliding if the court should change its mind down the road. There are currently 6 states that have eliminated deference legislatively, 7 where the courts have done it, and 1 state, Florida, where the people have done it through the ballot. Only 8 states allow deference right now, and the rest of the states, as I said, are inconsistent in how they apply the doctrine. And then 3 other states, Idaho, Nebraska, and Tennessee, have adopted language very similar to 222 that creates the de novo standard, and then in the second part creates the standard that the tie goes to the runner. This idea that the rule of lenity, that when the government is prosecuting someone in an agency action, that if there is uncertainty about how the rule applies, that the default should be in favor of individual liberty, as is the purpose of all government, to protect individual liberty. So it's a great bill, and we're happy to support it here today, and I'm also happy to answer any questions that you may have.
Thank you. We're going to go ahead and hear from proponent conferees and then have questions at the end. So next, we're going to invite Brian Norman, Director of State Affairs, Goldwater Institute, to testify. Please introduce yourself and welcome to committee.
Chair Warren and members of the committee, my name is Brian Norman and I'm the Director of State Affairs at the Goldwater Institute, here to speak in support of SB 222, which seeks to codify the Kansas Supreme Court's approach to judicial deference. The Goldwater Institute works in courtrooms, capitals, and communities nationwide to protect constitutional rights and empower individuals to live freer lives. And while I can't do much of a better job than Mr. Manley up there, he's quite the subject matter expert on the topic. I'll do my best. Across the nation, government agencies often apply overzealous interpretations of their own statutes and regulations, which serve to expand their own power in enforcement or regulatory proceedings. In some states, these generous interpretations are then upheld by deferential courts, which can expand agency power in a manner that goes against legislative intent. This dynamic effectively turns administrative agencies into lawmaking entities that step into the constitutional domain of the legislative branch. In fact, in 2024, the United States Supreme Court finally recognized that agency deference is fundamentally unfair and that courts have the sole constitutional duty to interpret the law by overturning Chevron deference and Loper-Bright v. Raimondo. Fortunately, the Kansas Supreme Court rejected deference to state agency interpretations of law in 2013, but the Goldwater Institute recommends codifying and strengthening this standard by passing SB 222. This bill ensures a level playing field by requiring courts to review agency actions without deference. This provision ensures that judges are neutral arbiters of justice rather than parties biased in favor of administrative power. The legislation's presumption in favor of limiting agency power creates a necessary check on the administrative state's ever-expanding shadow over our individual liberties, and it also protects the legislature's constitutional lawmaking prerogative. In 2018, based on legislation developed by the Goldwater Institute, Arizona became the first state in the country to adopt this type of reform. 13 other states have since followed suit via legislation or through court decisions. And just last year, Indiana, Idaho, and Nebraska each ended judicial deference by adopting similar legislation. SB 222 will protect your constituents' constitutional rights before deferential judges and protect the legislative branch's sole authority to create law. And we urge you to support this bill. Thank you for your time and consideration.
Thank you. Do we have anyone else wishing to testify as a proponent? Then committee, I also want to direct your attention to proponent written-only testimony at your desk from Elizabeth Patton, State Director for Americans for Prosperity, Kansas. Any questions? Senator Titus.
Thank you, Madam Chair. I just wanted to clarify, Mr. Manley, you did say Kansas doesn't have this protection, but based on the current courts, unless we had another Supreme Court ruling, we do actually have this non-deference doctrine, right?
Please go ahead and reintroduce yourself. Thank you.
Jim Manley, Pacific Legal Foundation. Madam Chair, Senator, if I said that, I misspoke. Kansas does have this protection, and this would codify the protection.
I may have misheard too, but thank you.
Senator Corson.
Thank you, Madam Chair. My spidey senses just kind of always start tingling when we have out-of-state organizations coming in and telling us what laws we ought to pass here in Kansas. So for both of our proponents, can you talk to me about who your largest, maybe top 5 funders are, just to get a sense of who's supporting your organization, who would benefit from these changes, and how you raise your money and who's funding your operations, just because I'm not familiar with either of your organizations given your out-of-state entities.
And we'll give some leeway with that question. It's a little bit not germane to what the bill does or doesn't do. So at your discretion, you may go ahead and answer.
Madam Chair, Senator, I fear my answer will be unsatisfying because I don't know the answer to that question. I honestly don't. We are a 501c3. We're funded by thousands of individuals across the country who believe in our mission to protect property rights, separation of powers, and equality and opportunity. And I think it's fair to say that our mission is dictated by those principles and by the judgment of the folks on staff. Beyond that, I don't really know the more details to answer your question.
And for the other folks, would they care to chime in?
Can you hear me?
Yes, please go ahead and reintroduce yourself. And again, you can answer using your discretion.
Brian Norman at the Goldwater Institute. Pretty much the same answer as Jim. Our mission is dictated by our underlying principles to protect individual constitutional rights, and a good means of doing that is by passing good legislation across the country, and that's what this bill seeks to do, and that's why we support it.
Thank you. Can I ask one follow-up, Madam Chair, if I'm?
Sure.
Okay. On the substantive piece, the part that I worry about the most is on lines 16 and 17, where we're talking about that it's a state court or an officer hearing an administrative action shall exercise any remaining doubt in favor of a reasonable interpretation that limits the state agency's powers and maximizes individual liberty. My concern there is I'm worried that we're interjecting real uncertainty among these courts and these hearing officers as to what exactly that means and how they should interpret that. Because I mean, I think about our work here in the legislature, and I think all of us here think that we are trying to do things that are maximizing individual liberty. But if you've listened to a debate on the Senate floor, you know that we often disagree about what the specifics of maximizing individual liberty and whether a particular bill does or doesn't. And so I worry about putting our judges and our hearing officers in this really difficult position of having to interpret whether or not something maximizes individual liberty, because that seems to me something that's really in the eye of the beholder and something that's going to be a difficult rule for courts and administrative agencies to establish and have that followed in a consistent basis. So I worry about putting that into statute. Thank you.
Madam Chair, Senator, I think so two things to point out is one, that provision only applies after the court or agency, the hearing officer, has applied customary tools of interpretation and rules of statutory construction. And even after doing that, it's unclear which way the statute points. So to give a clearer example of how this would work is if the agency comes in to prosecute an individual for violating a rule, and there's a dispute about whether the statute actually authorizes that rule, and at the end of the day, it is the rare case where it's entirely unclear whether the statute gives the agency that authority. In that case, as I said, the tie goes to the runner. The individual would win in that situation where the scales are even. It's a rare situation, but it does happen, and it's consistent with other legal principles that contracts are construed against the drafters, that statutes are construed narrowly under the rule of lenity when someone is being prosecuted under a statute, the idea being that you should, as an individual, have a clear notice of what is prohibited and what isn't. And so it's applying those same standards. It's not too different from the way courts interpret laws that invade constitutional rights, where courts look to whether the law is actually necessary to achieve the government's interest and whether it's narrowly tailored. Those are the same sorts of considerations that would go into this applying this standard here.
Thank you. Is the bill similar to language in case law in Kansas that's been decided by the Kansas Supreme Court?
Madam Chair, it is. It's very similar in applying the de novo standard. And then the second portion doesn't echo Kansas case law on deference, but it's consistent with those other principles that I mentioned.
Okay, thank you. And then Senator Clays.
Thank you, Madam Chair. It's a very interesting discussion, and I for one appreciate when people come in with great ideas from other states. But I do agree with my my fellow senator that I do like transparency a lot too. I mean, it'd be great if you just had that on your website. It'd be nice to know. But I am not a lawyer, and I'm having trouble following some of this. When you guys are talking about de novo, and we need a law school curriculum right now. But if you can kind of maybe use some words that some of the rest of us can understand, that'd be really helpful. Thank you.
Madam Chair, Senator, my apologies. So all that means is that when, as I said, there's this dispute between an agency and a regulated party, and there's a question about whether the statute gives the agency the power to do something. In states where deference is the standard, if the agency comes in and says, we have the power to do this, and the individual says you don't, the court simply puts the thumb on the scale in favor of the agency's interpretation of the statute. De novo just means, I never took Latin, but it means new, to look at it with fresh eyes and without putting the thumb on the scale in favor of what the agency's interpretation is. So it simply means clear the table, start fresh, use your judgment as a judge, what we've hired you to do, and look at the actual text of the statute and determine evenly what does the statute actually mean? What power does the statute give to the agency?
Thank you. Actually, I did take Latin, but it turns out it's not very helpful when talking to lawyers, interestingly. But thank you for your response.
Thank you. So courts are used to applying the de novo standard and interpreting statutes and weighing these kinds of considerations. So thank you. Senator Klemp.
Thank you, Madam Chair. And just because I was confused after you responded to Senator Titus's comment. So today we are just, I think, codifying what we already have today, if I'm not mistaken. And if that is the case, it seems like we're maximizing individual liberties, and it seems like it's pretty common sense legislation, and we're just codifying what we already have. Is that a fair summary of what we're talking about?
Madam Chairman, Senator, it is.
Thank you, Madam Chair. Thank you.
Thank you. Other questions? Not seeing any, then thank you for your testimony today. Appreciate you appearing. And we are next going to hear, oh, I'm sorry, we have one more question. Senator Titus.
Apologies, Madam Chair, but one other question. I have not reviewed the case in a while where this comes from, but if we amended this bill to just match the language in our current case, would that be something that would be acceptable? Or do you think there are flaws in how the court has phrased that? And I have not looked at it. I intend to this weekend, but just asking for a position.
Madam Chair, Senator, I think if you wanted to just directly match what the court has done, Section A is that. It's the de novo standard of review. Section B, where we talk about what happens in the case of a tie, I think is an important, helpful addition that's consistent with the way that courts interpret statutes, as we discussed, and as Senator Klemp mentions, it enhances individual liberty. And as I said, so Idaho has actually passed this same language. Nebraska and Tennessee have passed variations on this language, which are, I think, also good alternatives to the current bill, if the current language is, not to your liking. But as I say, I think the way that the second part ensures that the tie goes to the individual is an important addition to the way courts review agency discretion in these cases.
Thank you.
Thank you. And the Section B you're talking about, again, that's after the court would use all customary tools of interpretation and rules of statutory construction, meaning legislative intent, what does the actual words written mean, and other tools like that. And then it's just to clarify, if the court still can't determine, then this is a way to provide some guidance.
Yeah, Madam Chair, I think that's an important point, that this, as I said, this is where the scales are evenly balanced, and it is unclear to the court whether the agency has this power to prosecute an individual. And so in that situation, I mean, the rule of lenity already probably requires the court to apply this presumption in favor of individual liberty. I don't see any downside to codifying that in statute to say that if it is unclear even to the court whether the agency has this power, that an individual shouldn't be subject to that rule or restriction.
Is the purpose to codify it in part to make sure, I think you said, individual liberty and things of that nature?
Madam Chair, yes, and I think ultimately, not to point fingers, but if we're in a situation where the statute is unclear, then the question becomes, what did the legislature intend? Did the legislature intend for an unclear statute to be used as a tool to prosecute individuals? Or in that situation where the statute is unclear, did the legislature intend for the tie to go to the individual and the presumption of individual liberty to apply?
Thank you. Any other questions? Thank you for your testimony. Appreciate it. We will next hear from neutral conferee Warren Weeb. I apologize if I haven't said that right. Deputy General Counsel for Dorinda Mitchell, Kansas State Board of Healing Arts. Please introduce yourself and welcome to committee.
Yes, Madam Chair and committee members. Warren Weeby. That's okay. It's been pronounced differently my whole life. I'm here as the Deputy General Counsel for the Kansas State Board of Healing Arts, checking first to see that our written testimony has been received by the committee. And I'm not going to read through everything that is explained in that written testimony. The second item is, yes, we are neutral on the bill. And I think the main point I would like to convey from the board's perspective is we're neutral on the legislation. However, our number one priority would be, after we've said we're neutral, is to ask for an exemption for the Board of Healing Arts from the application of this legislation to the way the board operates. Now, a couple points that I'd like to emphasize on how the Board of Healing Arts exists. The legislature, has established the Board of Healing Arts with two purposes. Number one, the privilege of providing health care in Kansas requires a license. The first purpose the legislature has tasked the Board of Healing Arts with is determining that people that have licenses to deliver health care to citizens are qualified. So the legislature said, before you give a privilege of a license, make sure the applicant is qualified. The second part of the purpose that the legislature has given the board is to make sure licensees deliver good health care to the citizens of Kansas, and when licensees harm the citizens of Kansas, for the Board of Healing Arts to step in and to either determine there was a violation, issue a sanction, or at the extreme to revoke the privilege from being able to practice. So the board's operating purpose from the legislature is make sure physicians and other healthcare professionals are qualified, and then make sure each time they deliver healthcare to patients, to citizens of Kansas, that healthcare is good healthcare. Now, the second part about, did I hear a question or was that me? The second part that the legislature tasked the board with is the legislature's vision for how the board should be constructed based on membership. 12 of the 15 members of the Board of Healing Arts are licensees. So when we talk about agencies expanding power or agencies restricting individual liberties, what we're talking about is the 12 members of the Board of Healing Arts that walk out of their board meeting, which is going on today, they walk out into a practice and regulatory environment that they have to practice under the very same rules and interpretations that they've just sat through and determined as board members. So when the board determines rules and regulations, and we're right now in the middle of our 5-year review of all the administrative regulations that apply to healthcare through the board's actions, the board has to say, what is the purpose of this regulation? Does it meet our two goals of either a qualified licensee or delivering good health care by our licensees? And is it overly restricted? And as they're analyzing those positions, board members have to say, if this is an interpretation of what the legislature's asked to do, does it meet the two purposes, qualified licensees, good health care. And then their other conclusion is, if this applies to orthopedic surgeons, and I'm an orthopedic surgeon as a member of the Kansas State Board of Healing Arts, I have to walk out into the regulatory environment and follow the very regulation I just approved. So it runs counter to the fact that in this case, the people that exercise decision-making power over the healthcare practices of the individual licensees in Kansas are the very same people that are regulated. They are the stakeholders. They are the profession that's regulated. They are essentially, the legislature has trusted them to do their job. Now, I think the other part is when one of my jobs is when licensees do not follow the law, and the media is full of extreme examples of licensees who've delivered harmful care to hundreds of people in other states. Well, the board's job is to step in and say, that's investigated, looks like a violation. Let's investigate it. Let's determine if a violation exists. Let's sanction if there is a violation. Sanctions are determined by the legislature. So the board's authority to sanction has already been provided by the legislature. However, counsel for a licensee if we're not exempted from this, is always going to argue, hey, your license and the privilege to practice in medicine runs counter to my individual liberty to do what I want to do. And once you've got a privilege, that privilege is conditioned on you following the laws and the regulations that comply with keeping that provision or that privilege. So that's probably the main reason the board asks to be excluded from this, is a license is a privilege. A privilege granted by the government comes with restrictions and does restrict individual liberties. And so at the end of the day, I don't want to be in a hearing or in the Supreme Court arguing that good health care is somehow counter to individual liberties, and having individual liberties be the tie that goes to the individual. I would much rather be arguing that the tie would go to the citizens of Kansas that depend on the board to ensure that they're being delivered good health care by the licensees. Questions, and I hope I was brief enough and understandable.
Thank you. Committee questions. Senator Corson.
Thank you, Madam Chair. I would just point out for some of our newer members, I had the privilege of serving, and I know Madam Chair did as well, and I think still does, on the Joint Committee on Rules and Regulations. And it's just important to note that in Kansas, we already have a process whereby a rule or regulation is issued, and then it is reviewed by our Attorney General to make sure that it complies with the law, and then it is put before the Joint Committee on Rules and Regulations for further questioning and examination. Can you just talk a little bit about that process? Because I certainly didn't know about that when I was a newer member, but I think it's important for folks to understand the level of review and protections that we already have from overreaching or inappropriate regulations, especially by having our elected Attorney General look at those regulations and determine whether they are consistent with the law, and then having a further layer of legislative review. I'd also just note that, my view that you're here neutral, but asking for an exemption sort of tells the tale of maybe why this probably isn't going to be workable in practice for not just you, but for probably many other agencies. So if you'd just talk about that, thank you.
Well, I tried, yes, that may seem counter, but I wanted to make sure that our views were communicated. Chair Warren is also the chair of JCAR, and she has an intimate knowledge of all the review processes that regulations go through before they even get to the legislature as the final step. So, for example, the board is meeting today, the Board of Healing Arts. I just came out of the meeting, and the last item before I left was five-year review of a segment of regulations. So some of these regulations are being revoked. Some of these regulations are proposed to be amended. So once the board says, here's the beginning or the starting line of regulations, the board says in form, we have approved you going forward carrying these proposed changes to regulations. Then the lawyers for the agency have to make 3 stops: the Division of Budget, the Division or Department of Administration, and the Attorney General's office. Each one of those 3 stops has to give a stamp, an ink stamp on an original piece of paper. Each one of those stops determines various checks and balances on whether this is a good regulation. The Attorney General's role is to say, number one, tell me what statute authorizes this regulation. And number two, they look at it and say, does that statute authorize the regulation you've written? And sometimes they'll say, you don't have statutory authority to enact this regulation, or you're going to need to change this regulation so that it does comply with statutory authority. Then once those stamps are all given, and it's a long, on its very best day, it takes 6 months to change a regular regulation. On not its best day, it takes longer. So when all of those steps are completed, we then end up before the legislature for them to look at it and ask questions and determine, does this regulation pass merit to the point where it would be good for the state of Kansas and the citizens? When we go to JCAR, one of the most important questions that's asked by JCAR committees, which is the Joint Committee on Rules and Regulations, is have you spoken to the stakeholders that are impacted by this regulation? And have you done an economic impact study to determine what effect now comes to bear on the regulated parties or the citizens if this regulation comes to be approved? So you have the 3 steps of government, the 3 stops: Division of Budget, the Attorney General's Office, Department of Administration. You have JCAR, and we look at economic impact as one of those concerns. And then when that's all done, we now have a formal hearing that the public can attend, and they can ask questions. And if we haven't done a good job educating and equipping the public, then the public hearing, it can be contentious. If we have done a good job educating and equipping the public, no one may show up for the public hearing because we've addressed most of the issues that the regulation would come to impact. And then when that's all finished, it's published in the Kansas Register and the regulation becomes law. I look at you, Chair Warren, like you either I'm going too long or you've got a question.
I just want to make sure, since you're moving away from the microphone, that you're still being heard online. So that's all. So go ahead.
Yeah, no, I appreciate it. I just wanted, that was really helpful because I think there may be a perception or a misperception that sometimes these rules and regs are kind of just flying out the door by unelected bureaucrats, and that's not the case. It is the case. We have multiple layers of review. We have an elected attorney general on behalf of the people of Kansas looking at them. We have elected representatives on behalf of their constituents looking at them. So I just wanted to highlight, because we have a lot of folks on the committee who are new to this process. It was certainly not something I was familiar with, but I was struck as a member of JCAR about the levels of review that these things go through and the political accountability for them. So I thought that was a helpful answer, and I appreciate it. Thank you.
With all due respect, I don't find that answer all that very helpful, and here's why. So as chair of the Joint Committee on Administrative Rules and Regulations, I've heard you say a couple statements today that it has gone through some review and been stamped a couple of times through a couple different offices, including coming to JCAR, which is the Joint Committee on Administrative Rules and Regulations. You've said that the stamps mean that it's a good regulation, that it's good for the state of Kansas. And that is a policy judgment to be made by the legislature. So when we have the stamps of approval by the Secretary of State, by the Attorney General, by the Department of Administration, those are not stamps of approval that they are good regulation or good for the state of Kansas, as you have stated. Those stamps don't determine if the agency or the department has overreached in making policy. So it's up to the legislature to make policy, not those who are employed in our departments or agencies. There's no questioning by the legislature in JCAR of whether it's good regulation or good for the state of Kansas, and here's why. JCAR, though regulations do come to that committee for review, I want to be clear, JCAR as a legislative committee does not have any authority to amend any of the rules or regulations before it, no authority to reject rules and regulations that are before it, and no authority to even approve rules and regulations that come before it. The only thing that JCAR can do when rules and regulations are presented in the process of, getting the stamp of, you've got to submit it to the Attorney General, the Secretary of State, the Department of Administration, and lastly, JCAR, and then a public hearing. The only thing that JCAR can do is ask questions. And ask questions, well, would the board consider this? Or, it's really overreaching. We, the legislature, find that this is a policy decision that should come to the legislature. But JCAR doesn't have any authority to direct that be done. And oftentimes, the economic impact statement that's required by the legislature when rules and regulations are presented isn't even filled out by the department or agency. And JCAR will look at it, and you haven't talked to any of the stakeholders, yet here you are in one of the last steps of process to get rules and regulations approved, and you haven't done what's been asked of you, haven't talked to the stakeholders. Would you go back and do that? Now, oftentimes, the agency or department will go back and conduct that, but they aren't required to, and the rule or regulation could still become law. So I want to be clear for our new members, for members of the public who may be listening, that the approval does not mean it's an approval that it's a good regulation or good for the state of Kansas. Those are policy questions that if the board or department or agency is making policy, they should come to the legislature so we can make that determination, because our boards and departments and agencies are not tasked with making policy. So I didn't mean to get into rules, the Committee on Rules and Regulations, but since that was brought up, it's not a terribly, well, that's what the committee can do and can't do. We can't amend, approve, reject any rule or regulation before that committee. So just wanted to make that clear for folks. So, and with that then, we have a question from Senator Shane.
Thank you, Madam Chair, and thank you for the conversation on the regulation process and for clarifications there. Would it be your position then, if you're seeking an exemption for the Board of Healing Arts, that the Board of Healing Arts is infallible in its interpretation and development of regulations and its enforcement of those regulations?
By infallible, I mean would never have an opportunity to make a mistake.
Correct.
I don't think anybody representing the human endeavor could make that promise and make it truthfully, or that they could stand behind it. So
would it be
no,
appropriate to have one agency exempted or one organization exempted and not the others?
Pardon me?
Would it be appropriate then, if you would agree that the Board of Healing Arts is not infallible, that they would be exempt while other agencies or other organizations would not be exempted from this bill?
Well, I think in explaining that, what would move the needle towards the legislature being more comfortable exempting the Board of Healing Arts from this statute, which is how we interpret statutes or regulations, would be that as Chair Warren said, the parties that are being regulated are the practitioners that practice medicine and hold licenses in the state of Kansas. So surgeons that are making regulations and interpreting the law to apply to surgeons that do surgery in Kansas are going to probably necessarily have a boots on the ground or firsthand experience with how will this regulation impact the practice of surgery and delivering good health care to patients in Kansas. So that would come with the bias that would come from a practitioner. So if the Board of Healing Arts would have any bias, it would be its practitioners trying to deliver good healing arts from qualified licensees. And that may run counter to other interests. But again, that is what the legislature has given the board as a purpose. Make sure licensees are qualified and make sure licensees that have the privilege of practicing medicine are delivering good health care to our citizens.
I guess I would say, with all due respect, I think that during the COVID era, many legislators probably sitting in this room and citizens around the state would believe that the Board of Healing Arts exceeded its authority and and showed prejudice in its interpretation of the regulations, particularly during the COVID era when it came to a physician's right to independently practice medicine. So I do think that there are examples where interpretation and enforcement of the authorities granted the Kansas Board of Healing Arts were certainly exceeded.
Thank you. Any further questions? Not seeing any, then thank you for your testimony today. Appreciate it and willingness to answer questions. Do we have any other persons wanting to testify neutral on the bill? And I can't remember if I asked that same question for proponents, so I'm going to say, do we have anyone else wanting to testify as a proponent, neutral, or opponent to the bill? Yes, seeing one. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Eric Stafford with the Kansas Chamber. I won't testify. I just want to say on record, I would like to get testimony submitted in support. Acknowledge your faults when you make a mistake. We have a new bill tracking software, and I haven't gotten used to seeing where the bills are and for hearing dates. I don't know how I missed this one, but I reported on it with our business lobbyist and said, hey, this is a really good bill, kind of deals with the reversal of the Chevron decision from the Supreme Court, or the Chevron doctrine. But if you're okay with it, can I get written comments submitted to the committee in support of the bill over the weekend?
Well, if you can turn those in today.
Today? Okay, we can do that.
Are you willing to take any questions since
Absolutely.
you're
Yeah,
here,
sure.
if there are any questions? I'm not
Sorry, like I said,
seeing any
mistake on my
questions.
part.
But, okay, well, if you can get your written submission made today, we'll put that then as written testimony since, okay.
That's great. Thank you.
Thank you. With that, then, not seeing any others wishing to testify, we will close the hearing on Senate Bill 222. We're going to open the hearing on Senate Bill 241, providing that restrictive covenants in certain contracts are enforceable and not considered a restraint of trade in certain circumstances. And with that, a brief from the reviser.
Thank you, Madam Chair. Senate Bill 241 amends KSA 5163. This is the statute in the Restraint of Trade Act that talks about construing and applying the act. Current law there in subsection B provides that some guidelines for how this act is to be interpreted, and we are adding a provision there that if a covenant is determined to be overbroad or otherwise not reasonably necessary to protect a business interest of the business entity seeking enforcement, the court shall modify the covenant, enforce the covenant as it has been modified, and also only grant relief that's reasonably necessary to protect those interests. And then subsection C is amended to add 5 types of covenants that are deemed not to be restraints of trade. I'm sure the proponents are going to get into the details of those, so but they are described in my written bill brief if you want to look at those. And then finally, subsection D adds definitions of material contact customer and owner, which are used in those 1 through 5 provisions up above. And I can take any questions.
Thank you, Natalie. Are there any questions for the reviser? Seeing none, appreciate it. Up first will be proponents, Eric Stafford. Welcome back, Mr. Stafford.
Thank you, Mr. Chairman and members of the committee. Good morning, Eric Stafford of the Kansas Chamber. I did know this one had a hearing, so that's why I was in the room and heard Senate Bill 222. I'm like, you got to be kidding me. I am prepared for this one today and do appreciate the opportunity to be here in support of Senate Bill 241. This bill, in our view, it's establishing clear guidelines and limitations as what constitutes a reasonable and legal restrictive covenant provision for owners and employees of a business. I do want to kind of make a clear distinction that Senate Bill 241 does not address or provide any guidance relative to non-compete clauses or non-compete covenants, which can prevent somebody working in a specific industry or within a specific geographic location. Those are often viewed as the most restrictive form or overly broad compared to the restrictive covenant provisions, and then just most recently, the Biden administration under the FTC order banned non-competes. So this is a different, they're two different concepts, right? There are limitations, and it's intended to be very specific for the provisions in Senate Bill 241. So the main pieces on 241 is there's a specific time period that these apply. For owners, it's 4 years. For employees, it's 2 years. And the reason the ownership provisions last longer is if I say I sell a business to somebody over here, that is a mutually negotiated, fair terms and agreed to transaction that it wouldn't make sense for me to be able to sell my business interests, whether it's a restaurant or a book of business, whether it's a lobbying firm, a law firm, an insurance firm, sell that book of business to somebody else in a negotiated price, and then go solicit those clients back from that individual to steal them away from the business that I just sold it to, right? So that's why the ownership interest is 4 years versus the employees that are 2. But in both circumstances, the restriction applies to what is defined, and I think Natalie mentioned this, as material contact customers. So those are the people that you are having direct contact with. So say it's a big firm, and I have material contact customers as defined in the bill, which are my direct customers that I had the book of business on, and I leave to a competitor, those would be restricted. I couldn't communicate with those. But other clients of the business that I just left would not be defined as material contact customers, and therefore would not be subject to the limitation as drafted in Senate Bill 241. So the material contact customers is key. These provisions in Senate Bill 241 do not prevent employment from a new firm, and it only again, I want to stress this, it only prevents solicitation of those direct individuals they had primary contact with. So these provisions are recognized across the country. They're recognized in Kansas. We're wanting to strengthen them in Kansas. We have good case law, but our case law isn't as clear as some other states. Missouri has very clear and definitive case law on these. This language is taken very similar from Missouri, very similar to Missouri case law. But again, it's intended to be limited in scope. And the clarity that we're trying to provide is both beneficial for the business, for the owner who is selling their interest, and then for employees who are looking to take a new job or change businesses. So it gives them a clear direction on what's acceptable, what's not acceptable, if they choose to stay within the same industry and move on, and who they can contact and who they can't potentially solicit. So we did receive some feedback, and we thought that there was going to be written testimony today. There wasn't. We did have some feedback from the Trial Lawyers Association on this. We were trying to work through some of the questions that they brought up, and then we haven't heard anything from them. And so we were trying to work that out, but then it's also my understanding that they did not formally submit opposition testimony to this today. So I don't know, I think maybe they're just watching it, but if there are concerns that are out there, we're willing to listen and try to modify the language in the bill. But if they've not submitted testimony, this is something we found out just before the hearing. So we were having those conversations over the last couple days. If there are concerns that you guys hear from, we're willing to sit down and work through those. But we know time is short. You guys are meeting for the last time on Monday, but we did at least have some of those initial conversations. But we do appreciate your time today and interest in Senate Bill 241, and at the appropriate time, I'd be happy to answer any questions and would respectfully ask for your support.
Thank you. Do we have anyone else wishing to testify as proponent on the bill? Not seeing any, then we'll open it up for questions. Any questions? Senator Klemp.
Thank you, Madam Chair, and thank you, Mr. Stafford. Having been on both sides of suits on this topic, one of the things I've learned in that process is there's typically on the sale of a business or clients, there's already strong contractual language that would bar that company or individual leadership from soliciting, trying to get those customers back. I'm curious how your thought process plays into things. If you're already working you're in that space, you're probably going to have contracts that kind of, whether it's 6 or 4 or 6 years on the side of companies. Do you have an opinion on that, or just? So this is just. I'll leave it there on my thought.
Do you mind repeating that question again? Because
Yeah.
you cut out a little bit and I couldn't hear the full question.
Today, if someone's selling a business and selling clients, there's typically a contract that's in place for that to happen, and usually those are pretty sound contracts. Is this in addition to that, or in lieu of that, or how would this legislation play into a contract that might already be in place?
If a contract is in place, say it's an ownership interest and it has a 6-year prohibition, that would, I think, if in place of this, would be deemed to be outside of the scope of what this is allowing. So by 2 years, because we have the 4-year ownership interest. So, yeah. So
let me state it maybe a different way. If I have a 6-year contract or an 8, which is kind of where some of mine fall, would that allow someone at 4 years to come back and try and acquire those customers because there's now a statute?
I would be more comfortable if I take your question and get feedback before answering, if that's okay with you. Just to be sure, I don't want to misspeak.
That sounds fine.
Okay.
I would be fine with that, and layer on that I would hate to, if there's contracts in place that are stronger, I would hate to hurt those contracts.
Yep.
All right, thank you. Thank you, Madam Chair.
Thank you. Senator Shane.
Thank you, Madam Chair. Mr. Stafford, I just want to double check. So you mentioned case law. We do know, obviously, the Supreme Court issued the ruling and it changed how we view employment non-competes and that. Is there any pending litigation or any reason to believe that Supreme Court decision or any pending litigation would have an impact on this particular bill or similar bills?
No, because this is expressly not non-competes. And it's intended to not include non-competes to ensure that we're clearly trying to differentiate what a non-compete is and what a restrictive covenant it is, to where this is clearly intended to be not as restrictive as those and give a lot more flexibility to the individual, but also clarity to ownership interest or employee interests that fall under these circumstances.
Great, thank you.
Thank you. Committee, any other questions? Not seeing any. Then are there any other persons wishing to testify as neutral or opponent to the bill? Not seeing any, then thank you for your testimony, and we will close the hearing on Senate Bill 241 and open the hearing on Senate Bill 237, requiring the court to consider the value of retirement accounts if a person loses income for certain reasons, and eliminating the exemption of pension and retirement monies from claims to fulfill child support obligations. And with that, a brief from the reviser.
Thank you, Madam Chair. Senate Bill 237 makes some changes with respect to child support orders and retirement accounts. Section 1 amends KSA 233002. That's the statute about determining the amount of a child support order. Current law there simply provides that the court should follow the Kansas child support guidelines when determining the amount of support to be awarded. This bill adds that the court shall take into consideration and shall order the use of the total value of any individual retirement plan if the person has experienced a loss of income or termination from employment due to criminal conduct, loss, revocation, or surrender of a professional license because of professional misconduct, or any kind of voluntary underemployment. If a parent experiences loss of income due to one of those reasons mentioned, then the court shall order the use of the individual retirement plan accounts to maintain the existing child support obligation, either until all funds in that account are exhausted or the parent establishes some other way to pay the obligation. Claims for child support against one of those retirement plan accounts shall take priority over other claims. They shall not be subject to early withdrawal penalties if used for child support payments, and they shall be executed through the direct payment through the Kansas Payment Center. Section 2 amends KSA 233005. That's the statute that governs modification of a child support order. Current law there authorizes the court to modify an order within 3 years of the date of the original order when there's a material change in circumstance. This bill would provide that, as used throughout this section, a material change in circumstance does not include those 3 things we talked about earlier: loss of income or employment due to either criminal conduct, loss, revocation, or suspension of a professional license, or voluntary underemployment. Section 3 amends KSA 60-2308. That's the statute that provides what type of orders that pension and retirement monies are exempt from. Subsection C there is amended to provide that those certain qualified retirement plans or any other kind of similar retirement instrument or account shall not be exempt from claims under qualified domestic relations orders or child support orders that are issued under Article 30 of Chapter 23. And I can take any questions.
Thank you. This might be a question for research or for our neutral conferee. Do other states do this and allow this? Do we know? Maybe that's for the conferee.
Madam Chair, that's not something that I know off the top of my head. I don't know if
research
Natalie
knows,
would
maybe she could take a look at
that.
it while we're
Yeah,
listening to some testimony.
Look into that.
Thank you. Other questions? Yes, Senator Shane.
Thank you, Madam Chair. And this might be a research question. I guess I'm trying to understand how we could avoid, so it says not be subject to early withdrawal penalties on some of these retirements. And I guess mechanistically, I'm wondering how that can be the case if this is a state law and those withdrawal penalties are a federal issue.
And it might be the conferee could answer, maybe there would be penalties, and that's just how the process in the bill would work. So, all right, thank you. Any other questions? Not seeing any, then committee, we do have proponent written testimony at your desk from Brittany Jones, Director of Policy and Engagement, Kansas Family Voice, from Lucretia Nold, Policy Specialist, Kansas Catholic Conference, and from Alana Zimmer, a private citizen. Is there any proponent wishing to testify in person? Not seeing any. Then we will invite neutral conferee Ronald Nelson, Nelson and Yarnell Family Law Practice. Please introduce yourself and welcome to committee.
Thank you much. Thank you very much, Chair Warren. Committee, I'm Ron Nelson. As indicated in my written testimony, I am a family lawyer in Johnson County. I'm also on the Judicial Council Family Law Advisory Committee and have been practicing family law for about 40 years. I'm neutral on this bill. I will say that one of the items in particular that is addressed by this bill is of concern to me, is of concern to recipients of child support across the state. As I indicate in my written testimony, in past times, I've had different situations, particularly when there's been a self-employed person who had significant amounts in retirement accounts, individual retirement accounts, pension plans, et cetera, where they were not paying child support, either regularly or for significant periods of time, and that we had difficulty obtaining any payment on that because of the self-employment and because of the exemption of the various retirement accounts from collection. One of those in particular was over $100,000 that we simply couldn't do anything about because it was so difficult to obtain because of the self-employment, et cetera. And so that part of the bill is good. There is something that needs to be done about that, I believe. I'm not quite sure how that needs to be done. I'm not sure that the language of this bill adequately addresses that. One of the things regarding that in Section 1, for example, is the language refers to an individual retirement account or plan identified by certain federal statutes. The problem is that an individual retirement account is a different thing than those plans or accounts identified by specific federal statute that are qualified accounts. An individual retirement account is not qualified under the Internal Revenue Code, which is a technical matter, and qualified accounts have to be taken care of in certain specified ways, rather than an individual retirement account, which can be divided or distributed according to a court order. A second part with regard to that was touched upon by the reviser, and Senator, you touched on it, is the bill's provision that it will not be subject to early withdrawal. A state statute cannot tell the Federal Internal Revenue Service what it can or can't do. It's a conflict of law between state law, federal law, and you simply can't do it. In that situation, if there is money taken from an individual retirement account or any of the various qualified accounts identified, there would be withdrawal penalties, there would be taxation, there would be various other items considered in that, both state and federal, because it's income, especially if it is pre-tax monies that were put into that particular account. One of the additional concerns that I have with this bill is somewhat the structure of it. So we have 3 sections in this bill, and the first section deals with KSA 233002, which is establishment of child support. Section 2 deals with modification of child support, and Section 3 deals with the exemptions that are allowed under Kansas law. And none of these really deal with enforcement of child support themselves. So in Section 1, it states that the court will follow the Kansas child support guidelines in determining the establishment of child support. The inserted subparagraph 2 states that consideration if a person has experienced certain losses of income. I'll tell the committee that is already one of the matters, number 1, that is included in the child support guidelines. Number 2, it is already a matter that was considered by the courts as a matter to be considered even before it was put into the child support guidelines. If someone is trying to avoid the determination of child support or enforcement of child support, that's always something that a court will look at, and a court will impute income if someone is trying to show that they have lesser income than they may. So there is that, and criminal acts, loss of professional license are already included in the child support guidelines. With regard to that, one of the problems with including it in statute is there is a balancing that the Child Support Guidelines Committee must look at when it writes the child support guidelines in consideration, again, with both state law and federal law, and the different nuances of under what circumstances, what kind of criminal action, what kind of loss, intentional actions, etc. And so there become, or there come a lot of nuances in those various considerations that the guidelines look at, but that the black letter proposed amendment does not. Another part of Section 1 that is problematic is that in the establishment of child support, it states that the court should look at the total value of the retirement account in determining child support. The problems with that are, number one, how do you do that? It is not a stream of income, and child support is determined by looking at stream of income, a balancing between the parents in Kansas and most other states, and looking at the percentages of income to determine what the child's need is for child support, and then dividing that. It does make sense to look at retirement accounts for collection of child support, but if you have a lump sum amount, number one, in divorces, that is being considered in property division. So it's unclear how you would also determine that in determining child support if someone has lost a job, lost income before or after the filing of the divorce, when that account plan is already being considered to be divided. In Section 2, the problems are, again, defining change of circumstances and what it is not. Again, change of circumstances has a long history in the courts of what it is and what it isn't. There was one appeal that I had 20 years ago that basically said when it's a material change of circumstances, it's something that is a very detailed consideration that is up to the trial judge to determine whether it is material or not. And the Court of Appeals ended up saying, we know it when we see it.
Excuse me, I want to make sure that we have time for questions. So if you can make your last final few points, and then we'll open it up for any questions.
Yes, and
thank you.
Very briefly on Section 3, which is the exemptions, I think that is really where this issue should be addressed by providing that the exemption does not apply against child support arrears of a certain amount or certain period of time or a combination of those, so that recipients can obtain through retirement accounts of various kinds a significant sum of arrears. And with that, I would take questions.
Okay, thank you. Committee questions. Yes, Senator Bowser.
Thank you, Madam Chair. Thank you, Mr. Nelson. I understand the intent of this bill. I've got some concerns about it, though, and I think probably the devil is in the details, and I share Senator Shane's concerns as well. Just curious, hypothetically, if I had a prenuptial agreement in place and we spouses went our separate ways, I wonder how this, would this bill supersede that prenuptial agreement if my retirement accounts were kept on my side? I'm just curious. I can see a lot of potential issues with the bill.
With regard to premarital agreements, cohabitation agreements, any kind of agreement with regard to that, it cannot affect child support or child custody. And so even if there was that kind of agreement, the court is still going to look at and consider the income of the parties and would consider the holdings of the parties. Lifestyle is something that we often look at when it's difficult to obtain information about what the actual income is, because we look at what is in the child's best interests rather than the parties.
Thank you. Committee, other questions? My question at the beginning was, do other states for child support arrearages, so we're talking about not your current you're keeping up with your monthly child support obligations, but you're in arrears. You've missed some, you're behind, you owe. And then I think the intent of the bill, at least Section 3, is then at that point to require the parent who's under child support orders and is in arrears to access the retirement account, because the child support was needed for the child, last month when you didn't pay, rather than the parent getting to retain it for their future retirement for themselves. So do other states allow for that? Do you know?
I have not specifically looked at that. It would not surprise me if other states do. Again, the devil is in the details, because those other states would probably deal with how the early withdrawal penalties are addressed and other matters such as what happens with the taxation.
Right, and it might just be in those other states that, yes, you have to pay early penalties, not because you're current on your child support, but because you're in arrears and you didn't pay those past months. So, but the details and to see how that would work out.
One additional thing that I would say is that there is a qualified child support medical order that is used. I haven't seen it used in a long time, but it's a different kind of qualified order. So,
Committee, other questions? Did you testify that on Section 3 regarding the access to retirement accounts for child support arrearages, that would be something that, the details would have to be determined, that in the concept that you're comfortable with, or?
well, I think that is the best place to address collecting arrearages from retirement accounts, because that's the exemptions statute. I don't think addressing exemptions or what is or isn't exempt is really appropriate in the other statutes.
I see. So.
But yes, that 602308 is where exemptions would logically fit, or exceptions from exemptions.
Okay, thank you. Committee, any other questions? Not seeing any, then do we have any other persons wishing to testify as neutral on Senate Bill 237? Sure, so come to the podium and introduce yourself, please, and welcome to committee.
Thank you, Madam Chair. Alan Conroy from CAPERS. I'm the Executive Director of CAPERS, and I'd like to provide a few comments. I think a lot of the subject matter has already been touched on. I think our concern is trying to make sure that the CAPERS plan, which is a qualified plan under IRS guidelines and procedures, that we continue to make that qualified plan status. And that's important because then it, in terms of the preferred tax deferred treatment of CAPERS benefits and payments, that remains intact. And I think you might have some written testimony, but I think there's three areas in terms of the IRS. One is making, this law would require then making in-service distributions without a distributable event as qualified by the IRS. And those are things like, of course, the retirement, the death of the member, termination of employment. And so the bill would require us to make direct payments to the Kansas Payment Center without those currently qualified distributable events being satisfied. Taxability of payments, I think that's been touched on, and we do believe that this would be a taxable event then to the individual. And then I think also has been touched on about the early withdrawal penalties. We believe the IRS early withdrawal penalty of 10% would apply as well. So those are things, I think those three areas in terms of IRS compliance. But then perhaps maybe most important, the actuarial funding implications. I think currently the bill then would take contributions, take resources out of the member's account to pay, but it doesn't, the current bill doesn't alter the entitled KPERS benefits of those individuals. So the money goes out, we still have the obligation to pay the benefit. So in effect, that obligation really gets transferred to the trust fund because we would still be obligated to pay the retirement benefit to the member when they're eligible. So I think that's certainly a concern, and maybe there's some potential funding that might help address that. And maybe to your specific question, Madam Chair, we did some checking, and we have our own staff attorneys, Kathleen Billings, and our outside IRS tax compliance. We did some checking, and we believe there's 9 states currently that use the Quadro enforcement. I think you're probably all familiar with that, for one-time payments for past due child support. And they're listed in my testimony: Florida, Illinois, Indiana, Iowa, and so forth. Missouri are all examples of that. But our outside tax compliance counsel was not aware of any state that would authorize taking money out of a retirement account for sort of ongoing child support orders due to income loss or to help pay continuing monthly benefits for child support. And maybe I'll stop there, Madam Chair, and certainly respond to any questions if appropriate.
Thank you. So we received a document, but it wasn't in the form of testimony, so it wasn't included in testimony for today at 10:30. But since you're present, if you want to submit that as testimony later today, you can do so. And also, since you're present, if we have any questions, we can entertain those now. Yes, Senator Haley.
Thank you, Mr. Conroy. As mentioned, we don't have the written testimony, and not that I'm of a mind to try and make this bill any better, but in your testimony, would you suggest, or does it suggest means by which you address, certainly in terms of through the payment center and also from the withdrawals, is there amendment language or emphasis language in your written testimony that might augment what we have, or are we to try and craft something further?
I'm sorry, we didn't recommend specific language. I think we alluded to it that we thought language could be crafted, particularly for that Quadro approach for one-time payments for past child due support that we think, and if that'd be helpful, we could certainly attempt that.
No, again, I'm not trying to assist this measure in any way, but just wanted to have something in front of me to work with or to see that later from you. Appreciate your insight, as always, on so many matters, Mr. Conroy, and thank you, Madam Chair.
Thank you, Senator Bowser.
Thank you, Madam Chair. Thank you, Mr. Conroy. Good to see you again. I think I may have answered my own question here as I was thinking about it, but 9 states do a one-time payment. I'm assuming that's that maybe the court has done some calculation for the child to reach age 18, and then they would tell you what amount to pay. Is that?
That's right. It'd be a one-time event to help sort of catch up on those past due payments.
Thank you.
Thank you. Other questions? Not seeing any. And then if you'll want to go to the website and fill out the documents to get that submitted as written testimony, that would be helpful.
Certainly, and I apologize for not following the proper procedures, but
it's okay. We'll get that in. We do have committee opponent written only testimony at your desk from Marcelin Martinez, Director of Child Support Services, Department for Children and Families. Is there any person wishing to testify as opponent on the bill? Not seeing any. Then we will close the hearing on Senate Bill 237. Committee, it's a few minutes before noon. We do have a couple of 3 or 4 bills that I was wanting to work. We're not on the floor this afternoon, but we do have one day left, Monday. So with the committee's indulgence, if we could stay for a minute and take a look at some of those and see if we can have some final action. And I would like to first bring up Senate Bill 128. And 128 will get a brief from the reviser, but if you'll remember, we heard that Tuesday, creating an exception to certain mandatory reporting obligations for licensed social workers when working under the supervision of an attorney. So with that, a brief summary from the reviser.
Thank you, Madam Chair. Senate Bill 128 inserts exceptions for licensed social workers from general mandatory reporting requirements contained in 3 statutes, one relating to abuse of a child and 2 related to abuse or financial exploitation of adults and residents of certain healthcare facilities. Exceptions for those reporting requirements would apply for licensed social workers when working under the supervision of an attorney, and when the reason to suspect or believe that harm is occurring from the particular form of abuse triggering those mandatory reporting obligations arises solely in the course of the attorney's representation of a client or a prospective client is seeking the attorney's services in a civil, criminal, domestic, or juvenile matter. Corresponding exceptions are made in the employment statutes related to those 3 mandatory reporting provisions. The exceptions inserted into those 3 statutes would allow attorneys to require licensed social workers to maintain ethical attorney-client confidentiality when the social worker is working under the supervision of the attorney and the reporting obligations are triggered solely from the attorney providing services to a client or prospective client. I'd be happy to answer any questions.
Thank you. Questions for the reviser? Any discussion or a motion? Yes, Senator Corson.
Thank you, Madam Chair. My best recollection is that we didn't have any opponents or I think even neutrals to this bill. So if the committee felt like it was appropriate, I would make a motion that the committee pass Senate Bill 128 out favorably for passage and recommend placement on the consent calendar if other colleagues are in agreement of that as well. Thank you.
Second from Senator Shane. Any discussion? Then you all have heard the motion. All those, well, excuse me, let me say, would you please close on your motion first?
Yes, Madam Chair, I close.
Thank you. We're going to tidy up the procedure a little bit. So with that, then, you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion passes. Next, I'd like to pull up Senate Bill 156, and 156 concerns laser pointers and creating the crime of unlawful use of a laser pointer. And we heard that Wednesday this week. So we heard that we were all, most of us were virtual. Some of us were in the committee meeting room. So thank you for those who attended. And with that, a brief reminder from the reviser.
Thank you, Madam Chair. As the chair mentioned, Senate Bill 156 creates that new crime of unlawful use of a laser pointer, essentially directing the light of a laser pointer at a law enforcement officer or an aircraft or the flight path of an aircraft.
Committee, any questions for the reviser? Yes, Senator Haley. Okay, I'm sorry. Any questions for the reviser? Any discussion or a motion? Senator Haley.
Thank you, Madam Chair. I may have been confused because I was on the WebEx. Was this the one with public transit? There was some discussion for assault.
Thank you. There was some discussion from Public Transit Authority, I think was the name. Yes, regarding including the category of public bus drivers. And, you know, maybe the thought is we keep this clean because, you know, you start putting different categories in and then it becomes an endless list. And I'd have to ask the reviser, but it's already punishable, is it, for assault if you're pointing a laser pointer at someone and then they have immediate fear of imminent harm to themselves, and that could be prosecuted currently. Is that correct?
Yes, Madam Chair, you kind of hit the nail on the head there with the imminent fear of bodily harm. Yep. Then that would be able to be prosecuted as an assault.
We could prosecute that currently, so, but given that, we'll take some discussion or a motion. Yes, Senator Haley.
Thank you for that, that response regarding that particular issue. Is there a bed space impact? Did we get a, I didn't see it in the, in my packet from the Sentencing Commission on this?
That's a good question. Do we have a bed impact study? I think that would be in our emails. We've been receiving those in our emails directly, I think. We do have it, yes. So, Ms. Scott.
Thank you, Madam Chair. We do have that, and I'm sure that we could get Barbara to upload it as part and put it in your folders. But it looks like for fiscal year 2024, there were 766 convictions that were a severity level 9 person felony. And so it says this bill may impact prison admissions, but the total impact can't be determined. And the bill may impact the workload of the commission, but the total can't be determined.
Okay. Thank you, Madam Chair, and thank you, Ms. Knapp.
Thank you. Further discussion or a motion? Yes, Senator Corson.
Thank you, Madam Chair. I would recommend that the Senate Judiciary Committee pass out Senate Bill 156 and recommend it favorably for passage.
Thank you. Is there a desire to maybe look at the consent calendar? Not sure. So
I certainly would be glad to amend that if colleagues would feel that's appropriate as well. Glad to, Madam Chair.
So do you want to amend your motion?
I'll go ahead and amend my motion to that the Senate Judiciary Committee pass out Senate Bill 156 favorably for passage and placement on the consent calendar.
Thank you. Is there a second? So Senator Rose. Any discussion on the motion? Not seeing any, then you may close.
I'll close on that motion, Madam Chair.
Thank you. You all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion passes. If we could do 2 more as quickly as we have done these last 2, that would be concluding the work I kind of had in mind for us today. The next would be Senate Bill 157. And 157, we just heard yesterday, requiring warrants issued for failure to appear to be provided to a compensated surety, and changes the criteria for setting aside bond forfeiture and requiring remission. If we could have just a real quick one, and then we'll open it up. I don't know if this was seeking amendments or not, but go ahead.
Thank you, Madam Chair. As the chair mentioned, this just requires those failure to appear warrants to be provided to a compensated surety who posted bond. It also makes a few tweaks to the criteria for setting aside bond forfeiture, specifically if the defendant has left the country. And then it also creates that remission process that allows for the 95% remission to the bondsman if they return the person to custody within 180 days.
Thank you. Do we have, I can't recall, do we have a coming amendment on that? Is that one where we had some law enforcement testify on? I don't want to. 157. Do we have an amendment ready? Oh, we do. Look at that. So first of all, any questions for the reviser? Not seeing any, then we'll open it up for discussion or a motion, if you have a motion. Yes, Senator Bowser.
Thank you, Madam Chair. Senate Bill 157, we have some minor amendments that were proposed by Sheriff Easter, and these amendments were agreed to by the proponents. So this is mutually agreeable language. I would make a motion, Madam Chair, that we accept these amendments.
Did you want to explain it specifically or have the reviser do that?
We can have the reviser do it.
Okay, Ms. Scott, go ahead.
Sure. Thank you, Madam Chair. So the first substantive change is on line 15. You'll see there that it specifies that the court shall make the copy of the warrant available to the compensated surety instead of the sheriff making that available. And then the second change in line 31, the bill says that the bondsmen can get forfeiture set aside if they can prove that the defendant has left the country. This would change that to that they would have to show that the defendant has been deported from the United States.
Thank you. Do we have a second on the motion? Senator Shane, any discussion? Not seeing any. Do you want to close?
Yes, Madam Chair, I close.
Thank you, Senator Bowers, sir. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion passes. We're back on the bill. Any further discussion or a motion? Yes, Senator Bowser.
Madam Chair, I'll make a motion that the Senate Bill 157 be passed favorably out of committee.
As amended.
As amended. Thank you.
Very good. Is there a second? Senator Shane. Any discussion? Seeing none. Yes, Senator Klemp.
I just have a quick comment. One of the, we talked about in the hearing was the lowering of the 95% in the bill. Was there going to be an amendment, or somebody had mentioned they were going to bring an amendment on that. I didn't know if there was going to be one. So just thought I'd open that up for discussion and move forward.
I don't think we're waiting on an amendment on that, but I don't think so. But thank you.
Thank you, Madam Chair.
Okay. Any further discussion on the motion? All right. You've already closed on the motion, so all those in favor signify by saying aye. Those opposed, no. The motion passes. And we have one more. 186. And 186 we heard Wednesday, which was virtual, requiring probable cause affidavits to be made available to law enforcement agencies prior to the execution of a warrant or summons. So with that, a brief statement from the reviser.
Thank you, Madam Chair. Senate Bill 186 makes that change right now prior to the execution of a warrant. It cannot be made available to the public, and this specifies that it shall be made to law enforcement agencies prior to execution.
Thank you. Any questions for the reviser? Any discussion or motions? Yes, Senator Titus.
I would move that we pass out 186 recommended favorably.
Thank you. Is there something we want to put on the consent calendar or something to discuss on the floor? Senator Titus.
And on the consent calendar.
And on the consent calendar. Is there a second? Yes, Senator Bowser.
I'll second that motion.
Thank you. Any discussion? Seeing none, then you may close.
I close.
Thank you. You all have heard the motion. All those in favor signify by saying aye. All those opposed, no. The motion passes. Well, thank you for your work, committee. Appreciate it. And for staff as well, for the conferees and for those following along online. And we will have a full day on Monday as well. We're going to hear 2 bills and work some that day as well. So with that then, the meeting is adjourned.